Alright, ebusian for mamda mu na masi emfambre ye channel yiso. Medo bibiasi ediba ye channel yiso. Na masel say notification button ehun hia me ye pa obetene ne on. Say the updates bebe bia onso nsa be den e be ka no ahwe. Na bibia aye kama kama. Say the news e mu hwam na ye de bra mu. E brentima nyibre. Yenkotie ensem kakra ekoso.
We have heard. And you know that we report the case every now and then here on television. In reporting the case on television, we always have to be careful not to run foul of the contempt threshold. And so we are going to be guided by that as we have been guided. Today, we're going to lead you into one of the important cross-examinations that have happened in the Kwabena Eduboahin trial. Okay, let's go to it. Now, it's a cross-examination of can we start? Yes. Okay, they're going to put it together. It's a cross-examination of a lady. Yes, her name is the PW2, and PW2 is called Ruby Opokua Edumwa. Now, she was in charge of the finance and administration of the National Signals Bureau. So how it works is that when there's a criminal trial, the prosecution will begin to build their case. So the prosecution have the charge. They charge the accused person. The defense, they charge them. So there's a charge sheet. And the charge says that you so accused of stealing contrary to section Okay. So the prosecution opens their case in court and sort of merely announces the charges to the judge and to the court. The judge already knows, everyone already knows, but they have to put it on record. So they announce it again and say that we are prosecuting for this, that. They also tell the court that in prosecuting, we are going to be calling Mr. XYZZZZ to support our case. And that's what they call them, prosecution witnesses. You may have heard something about some people who are being accused now becoming prosecution witnesses. That's a matter for another day. Today, we are not on that yet. So the lady called Opokua, can I get the first page again? Ruby Opokua Edumwa is one of such prosecution witnesses. She's a director of finance for the National Signals Bureau, and Kwabena Eduboahin is being prosecuted for acts and omissions, or omissions and acts of something he's alleged to have done in his capacity as a Director General of the National Signals Bureau. So in that capacity, this prosecution witness too, Ruby Opokua Edumwa, was Kwabena's head of finance. And so they are talking about money. They are alleging that some money has been either stolen or misappropriated. So it's important that the head of finance comes to testify. And the head of finance is testifying for the prosecution against her former boss. That's what she's testifying against. So that's the stage that you need to understand. So that, okay, so you don't want me to go straight to it. So the theme one is the testifying to save herself. Now, the lawyers for Kwabena Eduboahin seem to be suggesting to the court that the entire testimony of Madame Ruby is designed for Madame Ruby to save herself one way or the other from prosecution. That's what the lawyers are saying. That's not what we are saying. That's what the lawyers for Kwabena Eduboahin, Atta and Co. seem to be suggesting to the court. And here is how we know that. So we go straight to the question and answer. So there's a question here that, have you ever filed an asset declaration form? Ruby says, no, my lord. Atta says, do you remember the last statement you wrote out for the benefit of Eoco? Ruby says, I do not remember. Atta says, is that the statement? So Atta shows her the statement, says, is that the statement that you signed out for the benefit of Eoco? She says, yes, my lord. And Atta says that, and you wrote it yourself? And then she says, yes, my lord. And Atta goes on to say that, what is the date on the statement? Then she says, 9th May 2025. Then Atta says that, do you know when the accused persons were arraigned before this honorable court? Then she says, no, my lord, I do not know. So her statement is signed, her statement that she gave to Eoco is dated 9th May. And so counsel for the defense asked her that, your statement is dated 9th May. Do you remember when the accused persons came to court? Because normally the statements are taken before you come to court. The statements are part of the investigation. So they are taken and then you come to court. So by the time you come to court, you have done your statement already. So she says she did her statement on the 9th of May. And then the lawyer is asking that, do you know when the accused persons were arraigned? She says, no, she doesn't know. Okay, then the lawyer gives her something, a document, and says, have a look at the charge sheet. He gives her the charge sheet. What date is filed? And then she says, my lord, it's 30th of April, 2025. Then Atta says, I suggest to you that was the date the accused persons were arraigned before this honorable court. And then she says, my lord, I am not aware. Then Atta goes on. I suggest to you that after the arraignment of the accused persons, before this honorable court, you gave the statement you referred to dated 9th May 2025. Then she says, yes, my lord. What the lawyer is trying to say is that the statement that you have written, you wrote it after the accused persons were arraigned. You didn't write it as part of the investigation, even though you were also interrogated. And when you were interrogated, you wrote a statement. But by the time you wrote the statement, it wasn't 30th of April. 30th of April is when they arraigned them. And your statement says 9th of May. So the lawyer is trying to understand, why is there a statement after the people have been arraigned? I'm not too sure what he's getting to. But these are the facts of the matter. Another question comes in. Even against the backdrop that you were investigated by Eoco, you were not charged. This one is what I missed. The question is, from the document you are holding, you were not charged with any offense. She agrees, says, yes, my lord. Then Atta says that even against the backdrop that you were investigated by Eoco, you were not charged. She says, yes, my lord. And the lawyer says, and you were very happy for that. It's a question. Then she says, yes, my lord. My lord, I believe investigations are supposed to find out the truth. So if Eoco deems it fit that I am not charged, I cannot comment about it. Good answer. Oh, well, I shouldn't comment on whether it's good or bad. I take that back. Atta says that the 3 statements you mentioned that you delivered to Eoco, they have excluded the statements you signed out to Eoco on the 9th of May 2025. Is that not so? She says, no, my lord. My lord, for clarity's sake, I wrote 3 statements, including this one. So the counsel for the defense is saying that the lady says that she wrote 3 statements. Only one has come. And the one that has come is actually dated beyond the time that the accused persons were arraigned. That's the point that the lawyer is trying to get to. And then she agrees. Then the lawyer then makes an application to the court as follows. Counsel for the accused persons. My lord, at this juncture, this Attachian speaking, my lord, at this juncture, we pray for your order for the 2 other statements to enable me continue with the cross-examination. The court, counsel for the Republic, is hereby ordered to retrieve the said 2 other statements from Eoco and file same not later than the close of day of tomorrow, 13th November 2025. Counsel may continue with cross-examination on a different line pending the filing of the statement ordered to be filed. Okay, so the judge agrees with Attachia that if the lady has written 3 statements and you brought only one to court, and the one you brought is actually dated beyond the time that the prosecution, the time that the accused persons were arraigned, then we need to see the other 2. And then the judge says, yes, prosecution, bring the other 2 statements. So we go on. We'll finish just now, don't worry. It says, the next one is, when you came into the space of Eoco, they informed you that the interrogation is being recorded. Is that not so? And then the lady says, yes, my lord. Then Attacher makes another application to the court. Counsel for the accused person says, my lord, I pray for an order that the voice recording be brought to court. Okay, so that's where the fight begins in court that day. So Attacher says there are 3 statements. You have one. We need both. He makes an application to the court. The application is granted immediately. The court says order it. Attacher further asks her that when you went to Eoco for interrogation, they recorded it, isn't it? The lady says yes, they did. They told me they were recording it. Attacher then makes application, my lord, we want that recording also. And then here is the response from Sermsai, counsel for the Republic. He says, respectfully, my lord, we are opposed to the request on grounds that the subject matter request does not satisfy the grounds for further disclosure. My lord, the Supreme Court recent decision is to all intents and purposes an obiter, and regardless of how elaborate the court puts it down, cannot constitute a ratio decidendi. Okay, good point. I believe she's making this point because Attacher may have argued that based on a Supreme Court decision, these recordings must be given. And the Deputy Attorney General is trying to distinguish, as they say, those Supreme Court decisions, calling them obiter. That's another conversation we can have. Obiter is not the main ruling. It's something that the judge says. The ratio decidendi is the main ruling. Ratio decidendi is Latin. Some say decidendi, which is the germane matter of. So if they take me to court or they take anybody to court and they say that you crossed the red traffic light, and the judge says that, yes, I believe that he crossed the red traffic light. I don't even like the black car he was using. Black cars are not very good because when you drive black cars in the afternoon, you can't see well. All of that, what the judge said, black cars are not very good. If you drive a black car in the afternoon, you can't see well. It's called obiter. It's not the main issue. The main issue that the judge was ruling was whether the accused person has crossed the red light or not. So Stremsai is saying, now what is important that can be imposed on the court is the ratio. Where Supreme Court has decided something, all other lower courts must follow the decision of the Supreme Court in a similar or the same matter. So sorry, I needed to digress to explain that. But let's get back onto the thing. So he says that the Supreme Court's thing was all not ratio. It continues. It says, my lord, this is the Attorney General speaking. The issues before the court is what determines what the ratio of a decision is. Correct. If the court decides to veer off and make pronouncements on matters which do not form part of the issues before it, and in respect of which arguments were never taken, the authorities on what constitutes judicial precedent is clear on the matter. And therefore, this court and all other courts are not in any way bound to follow a decision which is contrary to precedent. So the Attorney General opposed the point that the recordings from Eoco should also be brought to the court. He opposed it vehemently. He goes on to say, my lord, the precedent for this matter still stands, which is a Supreme Court well-considered decision in Bafuboni, which this court has digested in my lord's erudite, most immaculate ruling, which is that relevance is a key consideration in determining application for further disclosure, respectfully submitted. So the Attorney General is saying that the recording at Eoco is not relevant. And then Atta said it's relevant. Eventually, well, the Atta responded, but we will not take the response because we don't have time. And then the arguments continued. But eventually the court said, by court, the opposition is overruled. The audio recordings in the custody of Eoco in respect of the interrogation of Edith Ruby Opokuwa Edumwa, if any, be procured by the Attorney General and filed as a further disclosure, same to be filed not later than close of day tomorrow, 13th November 2025. So this is what happened. This is what happened in the court. So you get it, isn't it? Now the judge said, bring the other statements, bring also the audio requirement. So the Attorney General's opposition was overruled. All right. The cross-examination then continued. Atta said, I put it to you that the only reason why Eoco admitted you to bail on pain of incarceration is because you were a suspect. So the lady said that when she went to Eoco, she was admitted to bail. And Atta is trying to say that you were admitted to bail because you were a suspect. And then let's move on. She says, my lord, I do not know. And the question is, at the last sitting, you were making a comparison of two invoices which had the same invoice number NSC 006 generated by ISC Holdings Limited. Then kindly refresh your memory on this. So she says, yes, my lord, they give her some documents. Then the question is, the items as described in the two, these are the invoices for the purchase of the equipment that has become the center of this trial. The items as described in the two invoices are different. Is that not so? Says, my lord, there are two different items with the same invoice number. I remember I said we had not seen one for procurement of cyber defense systems in our payment records. What we had was the procurement of digitized investigative auditing systems with invoice number so and so in our records. Question is, with one of the invoices, it is addressed to you. It's addressed to who? He says, which one of the invoice addressed to who? He says, my lord, one is addressed to National Security Council, which was not the one we paid for. Then the question is, and the other is addressed to who? He says, my lord, the other is addressed to BNC Accra, Ghana. Okay. Then the question is there also NSC/BNC there? He says, my lord, it is BNC. Then the question is, can you see a customer ID on the invoice number so and so, which relates to digitized investigative audit system, exhibits B4? They show it to her. He says, my lord, the customer ID number is NSC. Okay. What is the customer ID number on the invoice relating to the cybersecurity equipment identified as the document? The answer is, my lord, the customer ID in relation to the procurement of the cyber defense system is NSC BNC. Question. So how do you come to know the invoices relating to the digitized investigative auditing systems? Then she says, my lord, the digitized investigative auditing systems, which is also NSC 006, was what we made payment for in our records. Then the question is, who delivers the invoices to you? Says, my lord, as I mentioned earlier, my boss is the one who sends it to me. Sometimes I am on copy in the email, but I still take instructions from my boss on what exactly to do. His boss is the first accused, Kwabena Dubois. Question is, when your boss has not sent a copy of the invoice to you and you are not kept in the loop in the email, you have no knowledge of the invoice. Is that not so? And said, yes, my lord. So the court then rules. Suit is adjourned to the 9th, 10th, and 11th December 2025 for continuation of cross-examination of second prosecution witness by counsel for the accused person. Witness steps down. So this is what happened. This is the latest. The lady is now being cross-examined. It turned out that two of the statements that she wrote, which the defense counsel were hoping to rely on, was not available. An application was made by Leonard Atta. It was successful. That application initially was not opposed by Sremsai, the Deputy Attorney General, who is a lawyer on account. Then another application was made by Atta that we want also the video recording, the video and the audio recording of the interrogation when you went to Eoco. And that was vehemently opposed by the Deputy Attorney General, but the court ruled against him. We do not know whether the Attorney General will be seeking to test this at the Court of Appeal, because he can file an appeal to the Court of Appeal asking the courts to, or maybe he can go with a straight application to the Supreme Court, an application in certiorari, to quash the decision of the High Court, to bring those things. We don't know whether that's what is happening. We are not sure. But right now, we also don't know whether those documents have been delivered. In fact, we have to check tomorrow with the courts whether those things have been delivered. But we don't know. But this is the latest on the Kwabena Dubois trial. So you can make how you want to see it, make it up in your mind. Let's see, Mohammed Amin Anta